develop. Unfortunately, though these rules are in place since 2000, it is hardly adhered to in any of these district judiciary. This is a grave issue, challenge before the district judiciary. We must formulate. It also appealed to the Learned Council also. Learned Council, unfortunately, are also responsible for many of these delays because of this Tariq pe Tariq, Tariq pe Tariq. This must be avoided. There are very few jurisdictions in the world which are so liberal in granting adjournments. Very, very few. If they grant it at a heavy cost, I have not seen, abhi tak wahi cost hai 50 rupiya, 100 rupiya. Lower court में जाइए 50 रुपया 100 रुपया से ज़्यादा नहीं लगाते हैं, डरते हैं वकील से. Judges also are scared because they don't want to be unpopular judges. These are systemic issues. This we must sit inside, without outsiders, of course, mostly. Inside our, closed rooms, and we must, think over. These are matters of introspection. We must think it over. How do we deal with these issues? Because non-adherence to timeline is one of the greatest cause for pendency in our judiciary. Yes, much has been spoken. I don't wish to time. My time was only for 10 minutes. I am almost reaching that penultimate part of my speech. I just want to end this. When I was a lawyer, I was very fit. I didn't have this protruding stomach. Then when I joined, it started growing. Prosperity in the middle. Not in my bank account, in the middle portion. Then suddenly I had one day I was feeling very tired. So I called the doctor. He came and said, "Sir, let me check your BP." He checked. It was so high. But I said, I never had BP in my life. I'm very fit. I play a lot of games. I'm fine. No, sir, you have BP. You have to take this medicine. Because he said, why it happens? That this is a disease peculiar to judges, which has been confirmed by the doctor in Supreme Court. I know all the honorable judges, they will not disclose their state of health because they're top secret, confidential. But I know that the doctor goes to every judge to measure their BP. And the doctor was telling me also, "Sir, this is a peculiar of judges. You are not the only one. All these have." So now from where this BP has come? Nobody would like to have this BP. It's just a sheer work pressure. I don't want to again go into, Justice Dipankar has elaborately discussed the reason why I go on, not depression, but depressed by the blood pressure. This is something, of course, there are many ways, solutions have been also suggested. Well, thank you for giving me this opportunity to share a few thoughts. As mentioned by Justice Sundres, this is something which can go on. And this is something which we are worried about, certainly, because we don't want to have many of these Jolly LLB serials coming up. Because otherwise, unless we mend ourselves, we make drastic improvement in but of course, for which the government has to do a lot of role to play. For improving the condition of the judiciary, they have to spend much more in the judiciary. They have to invest much more in infrastructure, in training, in various others. And of course, I'm today in the first session, of course, was dealing with mediation. This is something which also will, to a great extent, reduce the pendency, because as we are all used to this adversarial system, we are not able to shift to this gear of mediation, which is of a totally different nature. The lawyers have to be trained, they have to be educated about this system, which will, to a great extent, reduce the system on pendency, because the mediation, not only the Act of 2023, which has been, but this whole mediation, the scope of mediation is already there in various statutes. We all see from one of these, first was in the family courts at a time, but I don't know how effective it is in the district courts, because all the family courts are functioning, but I understand it is improving, but this is one area. And of course, as coming to mediation, the nature of scope, the nature of mediation is different in different contexts. If it is a commercial mediation, obviously, it cannot be the mediator who is specializing in family dispute mediation, because the psychology is different, the requirement is different, the skill is different. There are huge challenges, but I feel that mediation is another area which, if fully harnessed, the potential fully harnessed, can do a lot, can be a magic wand to reduce dependency in our system. Thank you very much.
Thank you very much, sir. Now I request Honorable Mr. Justice Manmohan, Judge Supreme Court of India, to share his view.
A very good afternoon to everyone. First of all, I must congratulate the Supreme Court Bar Association for having a discussion on this issue, because I was asked about pendency and how we intended to reform the system only when I visited universities abroad or spoke at the think tanks abroad. This, for the first time, I think we are having a dialogue in this country about this problem. So congratulations to the Supreme Court Bar Association. The advantage of speaking last is that everyone has spoken on the issue and nothing remains to be said. But I will just try to illustrate the points that have been mentioned by giving a few anecdotal references. According to me, the problem of pendency is not just about numbers. It is far deeper. It is about insufficient resources. It is about structural insufficiencies. It's also about archaic laws. It's also about how, on the administrative side, we tend to handle issues. Let me first talk about infrastructure deficiencies and how they impact at the ground level on a daily basis. Not many people understand this. I was Chief Justice of Delhi High Court, and I realized very soon that there was a huge gap between the working strength and the sanction strength of my district judiciary. So I decided to ramp up the recruitment. Within about 6 months' time, we were able to bring our actual strength at par with the sanction strength. Because in Delhi, there is no dearth of talent. You hold one exam and you get a good talent. We were assured all throughout by the state government that as soon as the recruitment takes place, infrastructure like a building would be provided. We did the recruitment and we could not find a building that suited us. I did not know where to seat the people whom I had recruited. Can you imagine? There is no place for them to sit. And I have recruited them, they have undergone training. So I start with the digital courts and make them sit in one room on rotational basis. This is how it impacts at the ground level. I was told in one court in Rohini, a family court judge was handling 3,700 matters instead of the average of about 1,200 or 1,300. So I decided to visit the court complex myself to find one small room where I could, make one judge sit. I went to one courtroom. I was told that by the judge there that a bomb blast had taken place over there about 1.5 years ago. Went to the other courtroom. They told me about 2.5 years ago there had been a shootout in the court. There is no space. And I have to make that judge sit in that district. I can't make him sit anywhere else. So there is no space. I have the judge with me. I have a trained person, but I cannot make him sit. This is the physical infrastructure. Now see the resource gap that is there. One day I went on a round. I used to take round of my district courts on a Saturday. I went there in the morning at about 11 o'clock. And I find that there is a huge crowd outside one courtroom, and the judge is not sitting there. So I went inside, found out what's happened, why is the judge not sitting, why is he late. I was told that he was sitting in his chamber. So I went, I met him, I told him there is a huge crowd outside the courtroom, why are you sitting in your chamber? He said, Chief, there is one PP which 2 courtrooms share. So till the public prosecutor has finished his cases in the other matter, in the other courtroom, he will not be available in my court. So how do I handle the bail cases without the PP being present? This is how it impacts at the ground level on a daily basis. And people say that we are asking for too much. We need the resources. They are required at the ground level if you want the issue of pendency to be addressed. And then, on top of it, we have a large number of archaic laws which are not in tune with the times. How do we handle complex issues? Issues that are arising because the economy is shifting, say, from the physical world to the digital world. Every day, a judge has to innovate. And with what resources? Today, unfortunately, take the panel lawyers who are appointed on the panel of public sector or of the state or of the government. Are they recruiting on actual merit? Take any state government. Let's take the case of Delhi. Whether it is A party, B party, or C party. In fact, there are only A, B, C parties in Delhi. And the panel lawyers are virtually recruited on party lines, unfortunately. So does a judge get proper assistance to decide a complex issue? And yet, because his name is attached to that judgment, he will try to do his best. He'll have to do work on his own. He'll have to do research on his own. Is the system being fair to the judge? I think we have to all analyze that. And we have to ponder over it. The government is also the biggest litigant. But yet we find that it is not being very responsible in this role. A large number of frivolous appeals are being filed on a daily basis. Why? Because there is mistrust in the system. As was pointed out, if an officer genuinely writes on the file that no appeal needs to be filed, he could be haunted by the police, by the CVC, or by any other investigative agency. So he says, why should I take the burden on myself? It's better to file an appeal and get it dismissed. As a result, the courts are getting clogged. The government also is bringing about legislations which it is not implementing. Government is propagating alternative dispute resolution mechanisms like mediation and arbitration. But is it following them? Is it adopting them? Recently they have said that they will not go for arbitration in big matters. I understand they have certain concerns with the way the arbitration system is operating. But they are in charge of the situation. If it requires legislative amendment, they must do it. But it does not mean that they'll give up on arbitration. which is a very important way of resolving complex disputes. Why can't they resort to mediation in contentious commercial matters where, say, it's a highway construction and everyone knows that if the matter goes to court and the project gets stuck, there'll be huge cost overruns. But no one will follow the practical way. Everyone says the burden should not fall on me. I should not get prosecuted. This mistrust in the system has to change. Without this peculiar problem being dealt with, I don't think we are going forward. And this mistrust, I am sorry to say, is also there on the administrative side in the courts. I have always wondered if the Chief Justice of a state has recommended one person as a judge, why should there be any debate about that name? The Chief Justice of a court is not to be trusted? How do you get talent? You have to trust the man at the spot. The Chief Justice of a state is not an ordinary officer. He's a constitutional functionary. And we don't trust him. The Supreme Court Collegium will sit on it, then the government will give its advice, the IB will give its advice. This mistrust in the system is costing us dearly. I think we need to debate the collegium system threadbare. I am finding a lot of challenges within the system, to put it mildly and honestly. It really needs to be examined. A high court judge can only function when he has full power and full authority. He cannot be scared of a transfer. You have to empower him. You cannot emasculate a high court judge by putting the fear of transfer in him. I think this is a very serious issue which needs to be debated. I have seen it in some courts, and I really am quite disturbed about it, and I think a real good debate needs to happen on this. Also, I would think that the laws that are now being brought in are being brought in without deep study, without deep examination. Brother Sundaresh mentioned about the Negotiable Instruments Act. It was brought about in 1989. Look at the litigation that has cropped up because of one single amendment in the Negotiable Instruments Act. In Delhi, in the trial courts, it's about 45%. Imagine 45% of the trial court litigation is under the Negotiable Instruments Act. And there was no impact assessment of the statute that was done before introducing that amendment. There is no ramp up of the infrastructure in Delhi when this amendment was brought about. So with the same infrastructure, we are dealing with 45% more cases. That's a real issue which needs to be highlighted and needs to be addressed by the executive. Take the case of IBC. Today, I think 7,000 cases are pending before the NCLT. It's a new body that has been created, but I think the calculation was not done of what would be the extent of cases that would be filed under that act. There are a large number of statutory amendments which have been done which say that a judge would hear this matter on a day-to-day basis. Let's take the case of sexual offenses. But if a judge has on his board 1,200 cases, how do you expect him to do that matter on a day-to-day basis? You're setting timelines which are bound to be breached from day one. Why have these laws when they are going to be not observed? I think the matter needs to be examined at all levels. And really, what we require is not just a mere transformation. We require to reimagine the entire system. We require to reimagine our laws. We require to reimagine how we work administratively. Why should the Municipal Corporation of Delhi have about 10,000 cases? It is not at war with its citizens. It should have a procedure whereby the citizen can go speak to the municipal council officers and resolve their disputes. They must tell them what is the correct way forward and follow this path and get the approvals. We have a large number of issues on the administrative side also. They need to be resolved. But one thing is there. By calling one institution as obstructionist, we are not going to move forward. We can only move forward if we all join hands. That's the legislature, the executive, the judiciary. There needs to be communication. There needs to be a dialogue. Without that, we will never become a powerful nation, a nation which can deal with new challenges like environmental challenges. Imagine today, certain things which we used to take as granted are now being agitated in courts on a daily basis. That is fresh air, which was taken for granted when I was young, or clean water. This was also taken for granted when I was going to school. But today, we have courts which have to grapple with this issue. Why should courts be grappling with all these issues? This is to be done on the administrative side by the government, by the executive. And look at the proportion or the magnitude of the problem. The courts have to step in because people have no other alternative and no other forum to appeal to. So in conclusion, I would like to say that all of us must work together. We have to reform the system. It needs to be reimagined at all levels. And then only we can become a Viksit Bharat. Thank you.
Thank you very much to all the speakers. Now I'll request Ms. Asna Gandhi to felicitate Honorable Mrs. Justice B.V. Naratna, Judge Supreme Court of India. May I request Mr. Upendra Mishra to felicitate Honorable Mr. Justice Deepankar Datta. May I request Mrs. Ashish Sinha to felicitate Honorable Mr. Justice N. Koteshwar Singh, Judge Supreme Court of India. I request Mr. Manish Mohan to felicitate Honorable Mr. Justice Manmohan, Judge Supreme Court of India. Dear member, this is to inform you that our... sorry. May I request Mr. Rohit Bas to felicitate Mr. Sanjeev Sanyal. Dear members, this is to inform you that our senior advocate and SCBA member, Mr. Srivatsava Raghavendra, senior advocate, who is from Karnataka, has thoughtfully arranged personalized pens with each participant's name, along with keychain. Participants are requested to kindly collect the same from the counter placed outside the hall. The items will be available during the lunch hours. You are requested to please check your name and collect your personalized set from the counter. Thank you. Request for good photograph. Ma'am, one photo.
Please join us for lunch, and the participant, please, the lunch is organized by Greater Bengaluru Authority. We will assemble here at 3 p.m. Chief Justice of India Supreme Court, Justice Suryakant, has already reached the venue. He will be shortly joining us at 3 p.m. Please note, thereafter we will have a group photograph of with all the participants and judges. We have made a special podium for a group photograph with all the distinguished speakers, judges, and the participants. So please assemble by 3 p.m. or try as earliest as you can. I'm sorry we are behind the schedule. We are making unreasonable requests from the participants. Please be cooperative in this effect. Dear participant, one of our member has lost the gold bracelet in the hall today. If anybody finds it, please deposit to any of the EC members. I will write the message in the group, and I've already informed the authorities also. Thank you.